see how they have the authority they're asserting here.
Their theory is that that is a direct conflict with Congress's statement in the statute that this is our policy choice with respect to what kind of sentence applies in this circumstance. And what I take them to be saying, and this is, I think, a really legitimate question, is do we have that same kind of conflict here? You suggest, and I think the linchpin of your argument is that Congress's determination not to make this retroactive is a statement that Congress did not want anybody who was already serving these sentences to benefit from this sentence reduction. But I think there's also the possibility that instead of that inference being drawn from the retroactivity determination, there's the inference that Congress did not want to impose all of the administrative burdens that would apply or that would arise if there was categorical application of this to everyone without, the way in which retroactivity works. If we believe that that's what Congress was saying, that's what Congress was saying when it said no retroactivity, there isn't a conflict with a circumstance in which you look at 3553A and you look at 3582, the compassionate release, and take into account something like sentencing disparity.
Well, Your Honor, I think it's difficult to look at 403B, particularly in context where Congress did enact other retroactivity mechanisms, and plainly did so because in the entire interregnum period between the Fair Sentencing Act and the enactment of Section 404, which made the Fair Sentencing Act of 2010's changes for crack cocaine offenders retroactive. And during that entire 8-year period, no one ever thought that Section 3582C1A1 could do work for at least some subset of those offenders. I think it's a little difficult to look at 403B in that context and see it as anything other than as a policy judgment to leave offenders who had final sentences stuck with their old sentence.
What do we do with the fact that Congress did not speak to its directive in the compassionate release scenario, that you look as a judge to 3553A, which allows for consideration of sentencing disparities? It seems to me that if you're right, Congress would have needed to amend the compassionate release statute, either within the statute itself or taking out 3553A or addressing it like it did in 994T to take sentencing reductions out of it.
I don't think so, Your Honor. I think that's imposing kind of a clear statement rule on Congress to exclude particular enactments of law from the operation of 3582C1A1. It certainly didn't do so in 924C itself in saying a defendant shall be sentenced to a particular offense. And to your earlier point about administrative burdens, I think what Congress would have been creating if it allowed for this kind of judicial parole system is an even greater administrative burden on the courts, because what it's reenacting is exactly what we had pre-Sentencing Reform Act, where there's kind of a forced rehabilitation scheme. We talked about this a little bit in our brief in RICO, the case the court heard last Monday, where offenders think that, prisoners think that they need to rehabilitate, and that's how they're going to get out, and so they work to rehabilitate. And 5 years from now, we'll see each of these 2,412 affected 924C offenders, to the extent they haven't already been let out, claim rehabilitation. And if that fails, they'll file another one a couple years after that. And I don't think that's the scheme that Congress was creating, which is even more burdensome than some of the streamlined schemes that were developed under Section 404.
Why did Congress distinguish, do you think, or do you know, the crack offense retroactivity from the 924C offense retroactivity?
Well, the crack offense retroactivity was actually making up for not a loophole, but a problem it perceived after the Fair Sentencing Act, where as the court discussed in Dorsey, it had made the changes effective from that day forward, essentially exactly what Congress then decided to do in 403B, and was making up for that for the set of prisoners who were still in prison for those offenses. I think actually the fact that Congress was deliberately doing that, that is, truing up offenders where it had enacted a 403B-like scheme, and at the same time enacting 403B, really does point up that contextually Congress could not have meant to be allowing the kind of thing that petitioners say they're allowing here. Nor would it just be 403B, because Section 401 of the First Step Act made some further changes to the drug sentencing provisions of 21 U.S.C. 841, changing the nature of the predicates. And for that, there is a 401B that looks exactly like 403B. And there's another, the Commission estimated in 2021, 3,742 offenders who'd be affected by that. So to the extent they're still in prison, it would be opening the door to sentence reduction motions by them. There's another level of the problem here, which is that the Commission's Rule B6 also purports to authorize reliance on other non-retroactive changes in law. So we will get things like, and are getting things like, claims under Booker, United States against Booker, which is non-retroactive about the changes to the guidelines, the advisory guidelines, and all sorts of other claims about non-retroactive changes in law. So you will get some kinds of things that would have been a problem, that would exhibit the sorts of problems I was mentioning in the last case, where something has to be retroactive in order to qualify as a valid Section 2255 claim. I mean, it's an overused—
Can I just ask you one more thing about the Commission? Yeah. How is it that the Commission is way out of line in a situation in which the courts were deeply split on this issue to begin with before the Commission even entered?
Well, Your Honor, I don't think the mere fact that the courts were split reflected that the Commission could resolve that reasonable policy disagreement, because as we—
So you're saying the Commission had to choose, it had to pick.
Well,
either
as we
you can never use it or you can always use it, because that was the split.
As we expressly told the courts, like once the Speaker, and is the Third Circuit recognized in this case, once one of the courts, the 6 courts that went in our favor as opposed to the 4 that didn't, I mean, once they agree with us that this is not a valid consideration under the statute, the Commission doesn't have the authority to adopt under the statute. And this is also what the 3 dissenting commissioners said. The Commission doesn't have the authority to adopt under the statute something that the statute doesn't in the first place allow.
That just means you disagree with the Commission's statutory reading. I guess I'm just trying to understand why it's unreasonable, given that some courts agreed or thought that it was okay under the statute. The Commission just, it seems to me the Commission agreed with the courts that didn't agree with you, said it was okay under the statute, but only under these limited circumstances. Why is that just completely an abuse of the Commission's authority?
I mean, to put brass tacks to it, Your Honor, the 4 courts that thought this was permissible under the statute are wrong. And it's not just it's not resolving some sort of, you know, you could do it one way, you could do it another way kind of disagreement between the courts of appeals. If you can't do it under the statute, which is what the majority of courts had said, then the Commission can't do it either. And they can't do it in a purportedly limited way that, as I've mentioned earlier, is not particularly limited. But as I was about to say, I mean, I think it's an overused kind of homily that Congress doesn't hide elephants in mouse holes. But this is a pretty big elephant to have hidden in this mouse hole for Congress to have done with Section 3582C1A1 reductions. And I don't think there's any evidence in the history, any evidence in the context that that's what Congress was directing these things at. I think this applies to both the cases this morning, both Section 2255 claims and non-retroactive changes in law. There are often cases in which Congress decides to ameliorate sentences going forward. The Court has described those as perfectly ordinary decisions by Congress. It's also the ordinary business of the courts to reinterpret statutes, which can also be non-retroactive, particularly where they're just dealing with procedural matters. And I don't think Congress was opening the door up for those kinds of claims either. Even if a lot of these claims are going to be rejected, they are quite burdensome on courts. That's true in the 2255 context, where you've essentially got new habeas motions or post-conviction motions. And it's going to be equally true in this case, where the court has to go through the individualized circumstances of each defendant and try to combine all the apples and oranges to figure out whether this particular prisoner is deserving of relief.